Hello.
Good morning. Apologies, I was having some technical issues that
Hello.
appear.
Can you hear me?
Yes,
Karen?
I can.
Oh, great. So was I. My apologies as well. We were in the same main hall.
Indeed.
But is the hearing where?
The hearing is here. This is where. So we've
Okay,
got.
so we're in the right place at the right time, and we haven't. I hope we haven't inconvenienced people too much.
Hopefully not. So can the teams please introduce themselves?
Hi, I can start on behalf of Hamad bin Khalifa.
Yes. Welcome.
Yeah, so my name is Aisha Bashir. My colleague's name is Christina Al-Talatani, and we will be on behalf of Hamad bin Khalifa, who are the respondents in this particular session.
Okay, and I see Christina also. Hi,
Good
Christina.
morning, everyone.
Welcome as well.
Thank you.
Hamad bin Khalifa. All right. Nice to meet you both. And then on the claimant side.
Good morning.
Good
I'm
morning.
representing Middlesex University, Dubai. My name is Dua Iqbal, and my colleague Dolly is here with us today. We're the appellant side.
I'm just making a note of the
Dolly.
names. I haven't found. Could you spell your colleague's name, Dua?
It's Sargam Purohit.
Sargam is your colleague.
Oh, Sargam, right.
Good morning to you both. And thank you to everybody for being here. Just triple checking. So this session is going to end at 10:30 is when we need to be done with everything. So in terms of time allocation, I'm just pulling up the rules. Okay, in the interest of time, I think maybe we can begin. Michael, how does that sound? Oh, I think you're muted, Michael.
Thank you. Yes, I'm very happy to begin. Are we only two judges?
We are only two judges, that's right.
Okay, right. I'm very happy to begin.
So as am I. So welcome everybody. We're in your hands. So please I think the claimant has the floor.
Good morning. My name is Dua. I'm the senior appellant. I'm going to be representing Mr. Laith Payne. If it may please the council seeks permission to address the bench as your lordship and ladyship. The council is appearing before the Honorable Court in the matter of Laith Payne and Raz Rani on behalf of the appellant under the DIFC Court of Appeal on appeal from the DIFC on appeal from the Digital Economy Court. Your lordships, there are two main lordships and ladyship. There are two main issues involved in the present case. The council will be dealing with the first issue, and my co-counsel will be dealing with the second issue. The council seeks permission to begin with the statement of the facts, if that's okay.
Please proceed.
Mr. Payne's program is called Beta, and it's programmed in such a way that if there are no other users offering to sell Yapple, Beta automatically sells Yapple at a highly inflated price. June 10, 2022, Clavity's software underwent a routine upgrade. As a result, there was an error. Clavity wrongfully excluded from the market users who had less than 200,000 and as margin in their account. Alpha and Beta automatically concluded a trade under which Mr. Payne sold 100 Yapples to Miss Rani. It is common ground between the parties that the disputed trade was concluded at a price 250 times greater than the prevailing market price, which was US $10 for one Yapple. The dispute trade was automatically settled by the Clavity platform, which recorded the transfer of 100 Yapple from Mr. Payne to Miss Razi and then debited Miss Rani's account for $250,000. When Miss Rani discovered what happened, she issued proceedings in the DIFC court, Digital Economy Court, seeking a declaration that the disputed trade was void for unilateral mistake. Mr. Payne issued an application challenging jurisdiction and in the alternate seeking immediate judgment in his favor point of law. The first issue of this case is of relevant mistake, which the council would be establishing on one ground. Relevant mistake under Article 37 of DIFC Contract Law, DIFC Law number 6 of 2004. There could not be a relevant mistake within Article 37 of DIFC Contract Law, DIFC Law number 6, 2004. Under Article 37 1A, a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation at the party would not have concluded it at all if the true state of affairs had been known, or the other party made the same mistake, or was also mistaken, or caused the mistake, or knew or ought to have known the same mistake, it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. And to reference back, under the Unidroit Principles, Article 3.51b, a party may only avoid the contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party in error would only have concluded the contract on materially different terms, or would not have concluded it at all if the true state of affairs had been known, and the other party had not at the time of avoidance reasonably acted in reliance of the contract. So Mr. Payne did not know that the error was about to happen, and he was asleep at this time of the mistake happening. So it was a matter of relevant mistake. And to reference to it, Cooper versus Phibbs, 1867, UKHL 1.
Well, counsel, why wasn't it a relevant mistake? Because both parties knew they were trading automatically. And when Mr. Payne woke up, he could have unwound the contract, couldn't he?
But at that time, the trade had already happened and the contract was already made.
Yes, but nothing else had happened. All he'd done was entered into this buying and selling arrangement at a massively increased price, 250 times more than it should have been. Must have been plain to him that there was a mistake.
It was the platform, the way it was, the way it was programmed is that when no other users are online, or so it sells it on a very highly inflated price. But my client was asleep, and Miss Razi was also asleep. So they did not know of the contract taking place. But by the time they woke up, the trade had already happened and the money was already transferred in their accounts.
Thank you, counsel. Thank you.
Thank you.
No questions from me.
The council now seeks the permission to proceed with the second pleadings.
And just to confirm, you're also from the claimant?
Yes.
Okay. Please proceed.
Okay. So the next issue which we would like to argue on, that it wasn't and couldn't be an unilateral mistake, as a unilateral mistake occurs when one party is mistaken as to the subject matter or the terms and agreement contained in the contract. We also specify that Ms. Rani, as lead Payne specified that Ms. Rani had made a mistake when she programmed her program. While programming beta, Mr. Payne did not repeat the same mistake, and there was no way or no grounds to avoid the dispute trade because he couldn't have known and he wasn't aware. In referring to this, the 1939 case of the United Kingdom of House Lords, Hartog versus Shields, where the seller had made a mistake in the price of goods, but the buyer realized it instantly and the contract was void because the mistake was realized. It was a pleasure speaking before the court.
Thank you. Can you tell us the factual background of the case that you cited? Was it House versus Shield?
Yeah, the Hartog versus Shields case, the seller had made a mistake when he was like selling out the goods. He had made a mistake in the price of the goods, but the buyer who bought the goods had realized the mistake then and there itself, and the whole contract of the buying and selling of the good was void because the mistake was realized.
Yes, and in Hartog and Colin Shields, the mistake was between two parties who were negotiating with one another, and I think the price had been per skin for which was one basis of calculating the price, and the other was per pound. And it was very obvious, wasn't it, that the party which quoted the price had made a mistake, and therefore it was undone. You say that in this case it wasn't a unilateral mistake, but then if my note is correct, you said Mizrani made a mistake and Mr. Payne did not repeat that mistake. Have I got your submissions right, counsel?
Yeah.
But
Yes.
why is that not a unilateral mistake? If Mizrani made the mistake, but Mr. Payne didn't, isn't that unilateral mistake?
Her mistake was not when the glitch happened. Her mistake was before the glitch happened. Her mistake was in designing the way the program she designed. Mr. Payne did not repeat the same mistake. He was very careful with his program. During the glitch happened, both the parties were unaware of the fact. And as unilateral mistake is, when one of the party is aware of the fact that a mistake has been made, aware to the agreements of the contract. But here, there on no grounds a unilateral mistake because my client was nowhere aware that this was going to happen.
If we stand back and look at, there's a mistake in common law and there's mistake in equity, isn't there, counsel? If we are with you on your submissions on common law, as a matter of equity, if the court stands back and looks at this, isn't it plain to see that there was a mistake because the trade went through at 250 times the value of the Yapple in market circumstances? Shouldn't we find that? Why shouldn't we find a mistake in equity?
But the trade had already happened before, the realization hit any of the parties. So on no grounds can the disputed trade now be null and void. The trade is already done. The money was already transferred.
So if Mr. Payne had said, well, offer it at £2,500, 2,500 times the price, 25,000 times the price, it would still be a binding contract, no matter how large the disproportion between the payment which was made under this contract and the price in the market. Is that the essence of your submission?
Yeah, that is basically the essence.
You can understand why the court might be reluctant to accept that submission because it could be extraordinarily unfair.
I do understand.
I have no further questions, colleague.
If I may go back to the first, to the senior counsel, you did mention one judgment, Cooper, is that right?
Yes.
Can you please tell me what happens in that case?
So in the Cooper versus Phibbs case, a nephew leased a fishery from his uncle. His uncle died. When the lease came up for renewal, his nephew renewed the lease for his aunt. It later transpired that the uncle had given his nephew a life tenancy in his will, the lease was held to be voidable for mistake as the nephew was already a beneficial ownership right in the fishery.
So in this case, there was a mistake.
Yeah.
And your position, counsel, is that there was no mistake for with respect to your client. Is that right?
No, there was a mistake in
There wasn't.
respect to my client.
Okay.
He
And
didn't
so,
intend for the platform to take place like that, and my client was mistaken because he was not aware of the trade happening because he was asleep at that time. If he were up at that time and he knew the trade was taking place, maybe it could have not happened and he would have done something to stop it.
okay, thank you. That's clear.
Thank you.
I think we might be ready for the respondent. Is that right?
Yeah.
Mhm.
Good morning, Your Honors. My name is Aisha Bashir, and I'm the senior respondent representing Ms. Razrani. My co-counsel is Christina Al-Talatani, the junior respondent for Ms. Razrani, and we are representing Ms. Razrani against Mr. Lee Kane on appeal from the DEC. Your Honors, this is a case about an unsurplus party who set out to take advantage of a trade that would never have taken place if not for a mistake, and is seeking to benefit from financial windfall resulting from the mistake of the other party, and this is unconscionable. Justice demands that when a party knows that their counterpart could only have entered the contract as a result of a mistake, the transaction should be set aside. Your Honors, on appeal, we argue that the trial judge did not err in applying Al-Kharafi versus Bank Sarasin in concluding that the DIFC court had jurisdiction over the claim by Ms. Razi, and we argue the trial judge did not err in concluding that it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC that Ms. Rani should show that a reasonable trader with knowledge of the circumstances surrounding the transaction could have concluded that the distributor was in error. I will be arguing the first stance regarding the jurisdiction of the DIFC, and my co-counsel, Ms. Al-Talatani, will be arguing the second stance. Your Honors, the DIFC has exclusive jurisdiction over claims, events, and incidents and activities with regards to transactions or contracts when they are wholly or partially within the DIFC under Article 5A(1)(b) of the Judicial Authority Law. On the issue of jurisdiction, we would first like to bring to attention the geographical aspect of the distributor ledger and the nature of the node itself. Your Honor, in our case, there was a node present within the DIFC, which was a distributor ledger on which servers were present that allowed trades to take place for the app of Clevity in order to have trades occur. A node, like a branch, is an extension of a legal entity, and therefore the DIFC has jurisdiction upon this matter. In
Counsel, can I just ask you to pause there? Is a node an extension of Clevity? Because
Yes,
as I
Your Honor.
understand it, nodes are simply voluntary participating computers. There could be an indefinite number in all sorts of locations around the world. Isn't it a step too far to say that each and every node is an extension of Clevity?
While that may be the case, what we are bringing forth is that a node is much like a branch in this case, that it helps us in performing the incidents, that the incidents occurs due to this node being present there, and also that the node itself merely is a way to have this entire thing take place, and that on the aspect of jurisdiction, you look at what can be sued and what cannot be sued. It is not the node that itself that can be sued in that particular instance, but that Clevity itself or the entire aspect of this and the claim itself can be done through this.
So, Counsel, should we not be finding the jurisdiction, which is the home jurisdiction for Clevity, or possibly saying that we should have recourse to the lex situs of the individuals, so onshore Dubai and Oman in the present facts?
Well, Your Honor, that would be difficult in the sense that if we were to look at, for instance, private international law, the nodes, as you have correctly stated, are all over the world, and it is difficult to then pinpoint exactly where to go. And also in regard to Oman and Dubai, the laws there, particularly regarding mistake, are far more broad as compared to the DIFC, which would then in turn make the issue more complicated, as well as the fact that we believe the DIFC is the best place in terms of forum non-convenes to be hearing this issue because of its expertise regarding emergent and current technological advancements of international and national natures, and the fact that when we discuss this, it would be best suited to bring the claim to this court.
Thank you, Counsel.
Thank you, Your Honor. So in the in Al-Kharafi versus Bank Sarasin, when they stated that a branch was not a separate entity but an extension of a legal entity, the place of jurisdiction for proceedings to which legal entity is a part shall include its extensions. This is under the assumption, as I've stated, that the entity will be sued or sue in the place of jurisdiction, and this principle shall be applied to the instant case. Clevity operated through a distributed ledger and did have a node within the DIFC, which can constitute as its branch. In Al-Kharafi versus Bank Sarasin, the court stated that the bank branch in DIFC was not a separate entity, but an extension of the main branch in Switzerland. Similarly, in our case, the node is not a separate entity. It is a unit of data structure, and nodes contain data and link to other nodes, and they hold servers and are an extension of the main system, not a separate system on their own. Further, the DIFC has jurisdiction because the transaction took place in the server, which was being controlled within a node on the DIFC. And when a particular commercial activity occurs, is carried out in the DIFC, which furthers or results in an incident or transaction, then the DIFC has jurisdiction over the claim arising from the incident or transaction, as we've seen in Al-Kharafi and Bank Sarasin, where any essential element of conduct or loss occurs that gives rise to an action, the DIFC will have jurisdiction. In the case of Al-Kharafi versus Bank Sarasin, the claimant's contracts were accepted within the DIFC, and furthermore, the claimant participated by telephone, email, and fax from Sarasin Dubai in DIFC, and sent instructions for investments through Sarasin Dubai, although these were not performed by Sarasin Dubai, but by Sarasin Switzerland, the main branch. The contracts were still partly performed within the DIFC, and the courts found that the branch was an extension, similar to how we argue that in our case, the essential element of the commercial activity occurred at the DIFC, as the node with the servers were hosted within DIFC, and that allowed for the trade to take place. Like Sarasin, where the branch within the DIFC was used to carry out the essential element that gave rise to the action. Similarly, in our case, the servers hosted on the node were what allowed the transaction between Ms. Razrani and Mr. Lee Payne to take place, and amounts to an essential element of the action and transaction occurring, and therefore the DIFC should have exclusive jurisdiction.
Well, Counsel, you say exclusive jurisdiction, but on your argument, let's assume there are 100 nodes around the world. And one of those nodes is in the DIFC, but 99 other nodes are in 99 different jurisdictions around the world. On your argument, if the contract is concluded through the DIFC node, then it must equally well be concluded at the point of all of the other 99 nodes, all of which are in different jurisdictions. How do you say the DIFC has exclusive jurisdiction when, in fact, from your argument, it wouldn't be exclusive at all? This case could be brought in any of the 100 jurisdictions where each of those nodes exist.
We argue that this is the exclusive jurisdiction is because the incident that is giving rise is particularly due to the node in the DIFC, and the DIFC is able to exercise its jurisdiction because of the location of the node itself and the incident occurring through that node.
But I was asking why you then say the DIFC has exclusive jurisdiction.
We argue for exclusive jurisdiction because similar to how in Al-Kharafi, the court found that exclusive jurisdiction would take place because of the branch being there and that they would not have a clause taking it away. We find that the circumstances in our case are similar to that, where this is merely an extension and that the extension can have the DIFC bring forth its jurisdiction on the matter.
Thank you, Counsel.
Thank you, Your Honor. And
Counsel, if I may, can you please point to the paragraph in the statement in the Moot problem that indicates that the transaction took place through the node in Dubai, in the DIFC? Apologies.
of course, while the problem
Oh, apologies, I can't hear
does
you.
not state particularly that it was the node itself. Oh, I'm sorry, can you hear me now?
Yes, there was a bit of a
Yes.
lag. I'm not sure if it was just me. Thank you so
No,
much.
I had the same thing.
Oh, it was probably on my error. I apologize. Our argument is not that it was per se exactly because of the problem itself, but that the presumption is that the node is there and hosting the servers as per, if you could give me a minute to look at my, yeah, as per paragraph 1, that one such node is on a server within the DIFC. And our argument is that the node is what helped facilitate the argument, the transaction. Therefore, the DIFC has jurisdiction because of its geographical location.
Are there any other connecting factors that would help the court find in favor of DIFC jurisdiction? Because the node question, I mean, it doesn't seem like factually we've established that the DIFC node was the determinative node in this case. It may have been, it may not have been. That's more of a technical question. Unlikely to have been. We don't know that from the facts that we're working with. Any other connecting factors?
Other factors regarding this can also be about the fact that the DIFC and DEC are courts that are specializing in this matter itself. So the Digital Economy Court, in its rules 58.73, includes distributed ledger technology as part of DEC claims. And this court is best suited to hear our case because of this. The DIFC does have jurisdiction, even if it would not be exclusive jurisdiction, and forum shopping in this matter would not be beneficial to either parties because the DEC court and the DIFC courts are designed to deal with matters such as this. And furthermore, a claim can be brought to DEC involving distributed ledgers and technologies in the same matter in a non-exhaustive list. In 58.7 paragraph 3, it states that blockchains, including applications based on blockchain technology, are part of the claims that can be brought forth. And the DEC is designed to hear cases regarding these emergent and technological advancements of international and national natures. And if we are discussing forum non-convenes and which could be a better party, if other nodes could be, or such as that, then if the parties were to go to Oman or the UAE, for instance, both of which have broader laws when it comes to the issues of mistake, and in the interest of justice and fairness, we argue that not only does that the DIFC does have jurisdiction at the very least, and the DEC and the DIFC are the best forums for this case because
Counsel, I know that both I and my colleague have been rather interventionist, so we have allowed you a certain latitude in time, but I would be, I think, speaking on behalf of the court, we'd be grateful if you could just very shortly summarize your arguments in terms of time.
Okay. To conclude my part of the argument, there are no incredible cost reasons that will make this course less favorable, and the court is designed for such cases. So on a balance of matters, we plead before the court to give due weight to these considerations, and I will hand off to my co-counsel, Christina Al-Talatani, for our second pleading. Thank you.
Thank you.
Good morning, Your Honors. My name is Anela Cristina Al-Talatini. I am a junior respondent, and I will argue that this is indeed a case of unilateral mistake and that Ms. Rani has the right to avoid this contract. The DIFC law does make allowances for parties who have genuinely made a mistake. For example, a party may avoid the contract for mistake if, when the contract was concluded, the mistake was of such importance that any reasonable person in the same situation as our party would not have concluded it at all if the true state of affairs had been known, and the other party knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of the fair dealing to leave the mistaken party in error. The DIFC law is similar to the rules of a number of common law jurisdictions. Therefore, the court may elect to be guided by these persuasive authorities, although you are not bounded by these. In common law jurisdictions, including England and Wales and Singapore, unilateral mistakes requires that one party has transacted while operating under a mistake as to a fundamental term of the contract. Unilateral mistake claims can be raised at common law or under the law of equity, and the rules of these different approaches are quite different. Algorithmic trades are novel and distinct in that the parties don't know what the terms would be until after the trading contract is made. And we will refer to the case of Coin versus B2C in 2020, which was the first time an unilateral mistake was applied to an algorithmic trade, and the judgment recognized that the existing body of law needs to be meaningfully adapted to deal with this type of novel situation. The Coin judgment considered the question of how algorithmic contracts are formed. The majority opinion found that the contract formation took place when the offer was made by one algorithm and accepted by the other, and that the parties agreed to the contract using the deterministic algorithms. Therefore, the parties were content to abide with whatever algorithms were built within the parameters of the program. So knowing about the mistake or the unconscionable behavior must be considered with reference to the person who created the algorithm when they created it up to the point the trade was made. So the question the court must consider today is, when programming the algorithm, did the programmer create it with actual or constructive knowledge that the offer would only be accepted by a party operating under a mistake, and did the programmer act in such a way as to take advantage of that mistake? If this is the programmer's intention, it does not matter that the relevant mistake occurred later. In our case, the respondent programmed Alpha to automatically buy YAPL at the best possible price available on the Clavity platform. The appellant programmed Beta to offer YAPL for sale at a highly inflated price if there are no other users offering to sell YAPL on the Clavity platform. Ms. Rani could have not foreseen a situation such as that of the disputed trade, where only one party would sell YAPL at an inflated price, and that would not have happened were it not for the unfortunate error caused by Clavity's software update. No reasonable person in the same situation as our client would have concluded the disputed trade if the true state of affairs had been known. Unfortunately, Ms. Rani was asleep when Clavity excluded all other users from the platform, except her program and Mr. Payne's beta program. She was indeed fully unaware of the unusual changes in the market conditions on the Clevity platform. On the other hand, Mr. Payne, being well aware of the prevailing market price for Yapple, can easily deduct that the disputed trade, which happened at the price 250 times greater than the market price, could only have happened due to an error. It is contrary to reasonable commercial standards of fair dealing to leave Ms. Rani as the mistaken party in error. Moreover, when Mr. Payne programmed beta to offer Yapple for sale at a highly inflated price, if there are no other users, did he do it with the intention to take advantage of other algorithmic traders such as Ms. Rani, who could never imagine a situation where only one seller would be available and dealing at such a highly inflated price? Would Mr. Payne's beta program ever be the only one available seller in normal circumstances were it not for Clevity's erroneous software update? We highly doubt so. Why should our client pay such a high price for something that was clearly unforeseeable and ultimately caused by the mistake of a third party?
Well,
No
Counsel,
reasonable
aren't we in the realms of allocation of risk? And can we go back to the case that you've relied upon, which is Coin? And as I understand it, the majority view was that the contract was valid, and it was Lord Mance in the minority who said that the contract was not valid.
That's
Is that correct?
That's correct.
Yeah, and then the majority started off the judgment by saying that in the realms of crypto trading, you trade at your own risk. There is a big risk in trading in this crypto environment. That's the first sentence of the judgment, I think, Counsel. Is that right?
That is true, Your Honor. But
and then Article 37.2 says, well, if a party, Article 37.2 of the DIFC contract law says, if a party undertakes risk, then that party is responsible if that risk arises. And surely your client undertook the risk.
Your Honor, that is correct. And we believe that the risk that our client was exposed to is too high compared to a normal risk of any other cryptocurrency trader. And we argue that this was a case of unilateral mistake because she would never be placed in those circumstances were it not for the software upgrade that caused the exclusion of all other users. I mean, it's not just a simple matter of risk taking when there are only 2 programs trading on a platform.
Thank you, Counsel.
Thank you, Your Honor. As for the appellant, Mr. Payne, he argues that the first instance court erred in concluding that for the purpose of Ms. Rani's claim to avoid the disputed trade, it was sufficient to show that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. We can go even further into defending our client's rights under the protection she is given for unilateral mistake by the law of equity. Following the judgment in Coin versus B2C2, the rule of the law states that the non-mistaken party must have had at least constructive knowledge of the mistaken party's mistake, and the non-mistaken party must have acted unconscionably relative to the mistake. If both parts are satisfied, the contract is voidable. The court needs to determine, in this case, that this constructive knowledge is objective. That means, would a reasonable person have known of the mistake? Unconscionable conduct, also referred to as sharp practice or impropriety, needs to be considered. The majority in Coin felt that there was no way to find unconscionable conduct on the part of the seller because he gave reasons for creating the program to contain deep prices, which did not involve an intention to take advantage of a mistake made by a counterparty to enter into a contract on that basis. The deep prices in that case was to ensure that there would always be price inputs to have continuous functioning to protect the seller from unexpected events. Also, the majority in coin found that the seller never considered any real possibility that orders would be placed at such deep prices, and his reaction to the result that the contract, the platform saying database breakdown, was inconsistent with a man with sinister intentions. Also, Lord Justice Mains, in the dissent, explained that under normal circumstances, a deep price bid would be ignored as entirely out of line with the available market prices, and in coin, the purpose of the deep price was just to manage the risk of uncertain liquidity and market conditions. Also in the dissent, Lord Justice Mains discussed the purpose of equitable remedies under the law. Equity may supplement the common law to give the courts jurisdiction in cases where there is a fundamental mistake of a nature not covered by the common law, or to give jurisdiction where the non-mistaken person lacks the requisite mental state required for common law relief. Referring to Justice Stain's decision in Associated Japanese Bank International versus Credit Union, the great attribute of equity is its flexibility to achieve the ends of justice. In the digitalmall.com case, the court said in paragraph 77, constructive notice is a concept of equity and must depend on the presence of other factors which could invoke the conscience of the court, such as sharp practice or uncivil conduct. Also,
But
Lord
Counsel,
Justice
there are limits to equity, aren't there? In that we can't rely on equity simply to rewrite the contract. And can you point the court to a term which your client was mistaken about, as opposed to just the general circumstances, namely the glitch created by Cleverty, which was responsible for the problem that has arisen? Was your client under any mistake as to any term of the contract between her and Mr. Payne?
Yes, Your Honor. Indeed, our client was mistaken in her programming, because she never expected that there would be only one other seller on the platform, and that they would be selling at such a highly inflated price. We think this is understandable mistake, because in any other normal circumstances, as I've mentioned before, there is no way that only her platform and Mr. Payne's platform would be the only ones trading. So when she designed her program and she built the algorithm, she never imagined such a situation. So that was her mistake, Your Honor. And we believe that the law of equity should grant her relief because she was unaware of this mistake, and also because Mr. Payne, the moment he found out that the trade had happened, he must have known for sure that this could only have happened due to a mistake. No other reasonable person would believe that this was a valid contract and that it happened under the normal market conditions.
Counsel, I know that I've been very interventionist again, for which my apologies. But to be fair to everyone in terms of time, certainly, and I don't know whether my colleague would be of like mind, but perhaps it would be helpful if you could just summarize your points very shortly.
Sure, Your Honor. Thank you very much. Your Honor.
May I just confer with my colleague and ask if she's happy with my invitation that you summarize the argument very shortly?
Absolutely. This is agreed. Thank you.
Thank you very much. So in conclusion, we plead with the court and honorable judges to give due weight to these considerations under the law of equity. It is clear that Mr. Payne had constructive knowledge of Ms. Rani's mistake, and Mr. Payne acted unconscionably relative to the mistake. We could not emphasize this enough. Any reasonable person knowing of the circumstances would know there was a fundamental mistake. Equity's conscience must be evoked. It is truly unconscionable for Mr. Payne to insist that the contract be performed and seek to retain the benefit of an unfortunate mistake from our client's side. And I think I can conclude with that.
Thank you, Counsel.
Thank you very much.
I would welcome, I don't know whether we can step outside the courtroom into a short retiring room. I'd welcome conferring with my co-counsel, with my fellow judge.
Yes, that's a good idea.
How do we, so please, counsel, do not go away, do not leave the courtroom. How do we have a chat between ourselves?
May I just ask first whether the parties have envisioned time for rebuttals? If the senior counsel for each party may respond. Okay, that does not look like anybody has.
Well, that was one of the points that I wanted to raise,
Yeah.
actually, in our retiring room, because I think there's a more fundamental point that we need to address as
Absolutely.
judges before we close the hearing.
Absolutely. So it looks like we can just exit this and we can come back later. We can exit and meet in the judges' breakout room, which is where we were right before here.
Okay, so we leave this and then so press the red button in the bottom right hand corner. I'll do that.
Short recess. Thank you.
Yeah.
Thank you very much.
Hello, I'm trying to. Hello, I'm trying to get into the judge's retiring room. If someone's listening. Hello. No, that's not it. So we leave that. Leave. Hello? Hello?
Hello, Your Honor.
Hello. And now I'm waiting for my co-judge, my colleague on the bench, to join us.
Apologies, had some trouble finding my way back here.
You're not alone, colleague. You're not alone, but we're back together. You're the presiding judge. Perhaps I should yield the floor to you.
I'm not the presiding judge, but certainly was not informed of that.
All right.
No,
well,
please go ahead.
Well, I think we should inform council that one of the reasons for having the recess was to establish that there should be a right of rebuttal by both parties, but also we were concerned that there are two questions which need to be addressed, one relating to jurisdiction and the other relating to mistake. And we heard submissions on both questions from respondents' counsel, but appellants' counsel seemed to us to have taken the sole question of mistake and split that question into two. And we thought it only fair, therefore, to invite appellants' counsel, that's Ms. Duar and Ms. I'm sorry, I've lost the name, Ms. Sargam, just to inform the court as to whether they have any particular submissions on the jurisdiction point. If you do, then we would hear you because we have not had the full argument. If you don't have any points on the jurisdiction question beyond what you've addressed us on, then we'd also like to know that. So could I invite Ms. Duar and or Ms. Sargam to tell the court whether they wish to address us on jurisdiction or whether they consider that they have had a full opportunity to present all aspects of the case they wish to bring on this appeal.
Your Honor, actually, we had the opportunity to appeal everything that we had, our points. That was mistake. And as you were right, we have divided the concept of mistake into two parts. And we do not have, as of now, any points on jurisdiction.
Thank you, counsel. And I take it that you are speaking on behalf of your co-counsel, Ms. Duar, as well. Now,
Yes,
that's very kind, and we're grateful for that confirmation. I think we have reserved probably 1 or 2 minutes, only a short period of time, but 1 or 2 minutes for reply by appellant's counsel and respondent's counsel. So, appellant's counsel, do you have any points of reply to the submissions made on behalf of the respondent?
I think that that's it. We don't have a reply.
Okay, thank you so much. Well, in those
Thank you.
circumstances, as the respondent would only have a right of reply to any points arising in appellant's reply, and as there is no reply on behalf of the appellants, respondents, there is nothing on which the court calls upon you to reply, because there is nothing which you need to reply to. So in those circumstances, again, conferring with my colleague on the bench, certainly as far as I'm concerned, I've asked all the questions that I would wish to. Fellow judge.
Yes, I share your position.
Thank you so much. And finally, counsel, before we close the appeal hearing, could I just confirm that you've had an opportunity to raise the points that you would wish to raise within the constraints of time that the court has been able to allow you, but have you had an opportunity to raise the points that you would wish to place before the court? Perhaps I can ask lead counsel Ms. Duar, followed by lead counsel Ms. Aisha, just to confirm whether you feel you've had an opportunity to present the points you wish to present. Ms. Duar?
Yes, Your Honor. I think that me and my co-counsel, we raised the points we wish to raise, and we're satisfied by it.
Thank you so much. And Ms.
Thank
Aisha,
you.
counsel for the respondent?
Yes, Your Honor, we have.
Thank you so much. In that case, I think, again, speaking on behalf of my fellow judge, we declare the hearing of the appeal closed. We will, of course, be reserving our judgment, taking full account of all arguments addressed to the court, certainly not a matter for an extempore judgment, and we will be handing down the judgment in draft form for corrections in the usual course by counsel in the fullness of time. Thank you all very much indeed for the submissions that you've addressed to the court today.
Thank you for your time, Your Honor.
Thank you.
Your Honor.
Thank you, Your Honor.
Colleague, do we have any points arising, co-judge?
Nothing. Oh,
Great. Well, thank you so much. We will leave the courtroom and we'll go into our judicial retiring room. Thank you all very much indeed.
Thank you very much.
thank you.
Thank you.
Thank you.